Good morning, good afternoon to everybody who is joining us. My name is Zsuzsanna Végh. I'm a visiting fellow at the German Marshall Fund. And today I have the pleasure to welcome you here at our latest launch of an excellent ReThink.CEE fellowship paper by Anna Wòjcik, who has been covering how the European Union could protect, safeguard media freedom and pluralism in Hungary and Poland in particular. Anna is a postdoctoral researcher at the Institute of Law Studies of the Polish Academy of Sciences, and as I mentioned, she is one of our excellent ReThink.CEE fellows. And discussing her paper, we have with us John Morijn from the University of Groningen, who was kind enough to agree to share his views both on Anna's paper and on the broader topic of the EU's potential actions in order to safeguard media freedom and pluralism. So just a few introductory thoughts and logistics. As it's widely known, democratic backsliding in the European Union has been a particularly crucial concern when it comes to the situation in Hungary and Poland, and a key component of these processes have been a capturing of the media in both countries by governmental actors and government-friendly actors in the past several years, where while the freedom and pluralism of media is a key component of safeguarding a liberal democracy, we have not seen significant action so far from the European Union to protect it and stand up for it within the European Union. So this is definitely an area of concern where further action is needed. So we have a really particularly timely paper from Anna touching on this issue. Before handing her the floor, I would like to highlight that our format today is a webinar, but you definitely have the opportunity to participate in our discussion. I would like to call your attention to the Q&A and the chat function, through which you can submit your questions, comments, and I will make sure to pick those up once we are done with our introductory round. So please use that. Please use that already during the conversation. I'll be monitoring that, and I will be feeding in your feedback, your comments, questions into our discussion. So without further ado, Anna, thank you very much for your excellent paper. The floor is yours. Please brief us on what you have found out.
Thank you very much, Zuzi, and thank you, John, for taking time this afternoon to listen and to comment on my paper. And also a big thanks to the German Marshall Fund for this opportunity to conduct research on such a vital topic. And I would like in my presentation to highlight the first map, but I think that most of you are more or less aware with threats to media freedom and pluralism that have happened in Poland and Hungary under the current nationalist conservatives government in recent years. But nonetheless, I would like to introduce them briefly and then move to the main part of the paper, which would be discussing the European Union's response to those threats, and finally to make recommendations regarding what the EU can and should do more. And I would like to focus mostly on the fact that we are really in a moment when there are European elections approaching in 2024 and also local elections approaching, and these are those that are actually covered by EU law, and therefore they give more room for maneuver to the European Commission and to other EU institutions, and I'm sure that John will follow on that. And I'm also particularly happy that Professor Morijn is here, because it was his article op-ed last year with Professor Adam Bodnar on the need of the EU institutions to step up its fight against decline of media freedom in Poland and Hungary, that inspired me to actually carry out my research in this direction. So I'm very much looking forward to your comments. And let me just begin by two quotes. The first one would be a very short quote from Viktor Orban, who during the election campaign this year addressed a conservative political action conference participants who gathered in Budapest. And he recommended American conservatives and other Trump supporters to simply have your own media. He advised that programs that promote Trump's views should be broadcasted day and night. Orban, of course, as we know, won these elections by landslide, by skillfully using Fidesz-controlled communication channels to pass the message to the voters that the opposition will be dragging Hungary into the conflict with Russia. And today we see that Budapest is undermining EU support for Ukraine, and that is actually increasing its plebiscitarian autocracy political system. In Poland, general elections are planned for next year, but we are already in a campaign mode. And PiS chairman Kaczyński has been touring the country, meeting with his selected supporters and passing them various bizarre messages, including one on the media. He said that media is still the powerful crutch of our public debate. We have a total opposition supported by an equally total media, which is able to create a counter-reality that people nevertheless believe in. One could think that this is basically a description of the media that his party created in Poland, but we may see that leaders of both countries are not stopping in their efforts to undermine media freedom and pluralism even further. So the main problems that we've seen so far include the lack of independence of media regulators, public media being turned into propaganda outlets for the government, characterized by reporting bias and by vilifying the opposition, private media capture, state disproportionately funding government supporting private media, including through state-controlled companies advertising, creating obstacles for private media independent of government, including through revoking licenses and threatening new taxes. Moreover, in Poland, and this is a bit of a particularity, the number of exaggerated, baseless lawsuits against media has grown in recent years. And in Hungary, we have seen that the media reported about allegedly illegal surveillance of journalists and publishers with software such as Pegasus. So as we know, media freedom is a prerequisite for free and fair elections, and the political bias of public media towards the governing party is a crucial element of structurally rigged elections. In both cases, in the case of Poland and in the case of Hungary, the reports of the Organization for Security and Cooperation in Europe's Office for Democratic Institutions and Human Rights have concluded that recent general elections and in Poland presidential elections were marked by the absence of a level playing field. In the case of recent elections in Hungary, OSCE audio has criticized systemic political bias and the virtual absence of opposition politicians in programs of the public broadcaster in Hungary. One well-known example is that during the general elections campaign, the leader of the opposition, Péter Márki-Zay, got only 5 minutes on public television to present his program. Moreover, pro-Fidesz and anti-opposition commercials in broadcast media and billboards dominated the public sphere, promoting Orbán's narrative that the opposition would drag Hungary into war with Russia. And similarly, in Poland, OSCE audio found that the public media bias tarnished the campaigns for the 2019 local elections and the 2020 presidential elections. they concluded that presidential election was free but unfair due to, among other things, bias toward the governing PIS or the incumbent President Duda, and lack of pluralism in reporting on the elections. Moreover, and this is really important for EU law folks, the public broadcasters in Hungary and Poland have been routinely presented anti-EU propaganda as objective information and smeared particular political groups in the European Parliament. Since 2011, Hungary's public broadcaster has participated in a smear campaign against members of the European Parliament from other member states who criticize the country's government. Moreover, private pro-government media have also investigated Hungary's opposition members of the European Parliament during the general elections campaign in 2022. And in Poland, after Russia invaded Ukraine, complaints were filed against the public broadcasters for statements about the European People's Party. So the main Polish TV channel, public TV channel TVP, suggested that EPP stood for European Putin's party. Furthermore, in both countries, private media ownership has become increasingly politicized. Private media capture means that individuals or private businesses, directly or indirectly affiliated to people in state institutions or the governing party, are gaining control over privately owned media, which results in them having control over a large number of outlets. And this process is particularly advanced in Hungary and has led to media concentration there. In Poland, PIS has used the state-controlled oil and gas company PKN Orlen as the economic vehicle to execute this process of media capture. And the state in Poland is using directed advertising to boost government-friendly, the so-called identity press groups. Plus, in both countries, governments have introduced changes that make funding and also operation of media independent of government more difficult. Radio and television channels risk their broadcasting licenses not being renewed or being arbitrarily revoked. An important case is that in September 2020, Hungary's Media Council, that is completely controlled by Fidesz, decided not to renew the license of Klub Radio, one of the few remaining independent radio stations. But it was not the last case. Actually, after this year's election, the Media Council refused to renew the license of a non-profit Tilos Radio, which has been operating since the 1990s. Similarly, in Poland, in 2020 to 2021, we've seen a big story regarding the fact that the National Radio and Broadcasting Council delayed the renewal of broadcasting license to company TVN24, to channel TVN24 that is owned by Warner Bros. Discovery, so US company. The channel was forced to obtain a license in the Netherlands, and eventually the council prolonged the broadcasting license a week after the previous one expired. We have also seen similar attempts with another channel, TVN7, that belongs to the same media group. And we also have seen that working conditions for journalists and editors have been decreasing because of those excessive lawsuits that I mentioned that are characteristic of Poland, and alleged secret surveillance used against investigative journalists and publishers in Hungary. So the EU response so far, as Zsuzsanna rightly mentioned at the beginning, has been somehow not very impressive. So we are for sure certain that the European Union's institutions are aware that the media freedom and pluralism crisis is going on in its member states. However, the EU has not contained or reversed any negative changes so far in this respect in Hungary or Poland. And we see that this response to the deterioration of media freedom and pluralism is qualitatively different from the EU's response to other elements of the rule of law backsliding. So we've seen that other responses to the attacks on judicial independence, LGBT rights, migration law, academic freedom, civil society organizations, etc., has been more decisive, and the EU could use legal actions more, or wanted to use, or was finally persuaded to use legal actions more. But in the case of media freedom and pluralism, the EU has so far focused on monitoring, political pressure, legislative action, and financing, and it has very rarely used legal action. So EU has extensive tools for monitoring media freedom and pluralism components. It has been founding various surveys and indexes. And importantly, since 2020, the European Commission has been publishing annual rule of law report that conceptualize rule of law as including media freedom and pluralism, next to the independence of the judiciary, anti-corruption framework, and other institutional issues related to checks and balances. Since this year, the reports also include a set of recommendations for national authorities, but these recommendations are not followed by any specific enforcement mechanism. What regards the political pressure, both countries have been subject to the so-called Article 7 procedure of political dialogue over the rule of law breaches. These procedures were launched for the first time in EU's history in 2018. They are ongoing. The scope of the procedure against Hungary is quite broad, and among other things, it includes media freedom and pluralism issues, whereas in Poland, the procedure is focused solely on judicial independence, on structural issues related to judicial independence. However, this execution of the Article 7 procedure against both countries has been broadly criticized as being largely ineffective. Because the EU Council of Ministers holds hearings concerning those countries infrequently, and the governments in Budapest and Warsaw maintain that EU values have not been attacked during all the hearings. This year, this procedure was somehow overshadowed by financial pressure applied by the European Commission against the governments in Poland and Hungary. The third area of EU's interest, and this is something that is really specific to its response to media freedom and pluralism crisis as part of the rule of law crisis, is legislative action. So one problem in the broader EU's response or difficulty is that media regulation has been traditionally the competence of member states. And I would say that was the biggest, I think, finding, my personal finding while doing this research, because I didn't expect that so little of media law would be actually codified, regulated on EU level. However, at the moment, the EU is working on a more comprehensive media freedom and pluralism protection system. And we have seen several elements of that. For instance, in 2021, the Commission adopted a package of measures to reinforce democracy and protect the integrity of elections. And this proposal includes legislative proposal on transparency and targeting in political advertising. This year, in April, the Commission also unveiled planned directive against strategic lawsuits against public participation. But the main mechanism to protect media freedom and pluralism is the so-called Media Freedom Act. According to the draft that was presented in September this year, the Media Freedom Act would require member states to respect the editorial freedom of media. And regarding the private media market, it would introduce a media pluralism test, which means that governments would be required to test any new legislative, regulatory, administrative measure in member states against the fact that the possible potential of this measure on media freedom and pluralism. And any measure should be duly justified and proportionate. Another element of the proposed Media Freedom Act is that it would introduce requirements for the allocation of state advertising so that it's transparent and non-discriminatory. Moreover, the Media Freedom Act, which is very controversial in member states, not only in Poland and Hungary, but mostly actually in Germany and France, is the new idea that news media would have to ensure transparency of ownership and guarantee the independence of editorial decisions, taking into account conflicts of interests. So we see that the draft MFA is quite broad, and it also includes, for instance, such safeguards against the unjustified removal by social media providers of media content, or regulations aiming at improving protection of journalistic sources and editorial independence, or strong safeguards against the use of spyware against media. So the most telling is that the MFA would be accompanied by non-binding recommendations. So we'll probably discuss it much more in the Q&A session, but one common fear is that this proposed regulation will be simply toothless and will not address the concrete specific threats that are existing in member states. And the next element of the European Union's response is legal action. So I'll maybe introduce it briefly to non-EU lawyers. The European Commission can pursue legal action against member states for failing to comply with their obligations under EU law. And this procedure has several steps, including the step that the European Commission may refer the member states' government to the Court of Justice of the European Union. And in this procedure, it may request interim measures, demand financial penalties, and also it may demand the penalties if the authorities are not implementing a judgment of the Court of Justice. So we have seen that the Commission has been quite broadly using this legal action, EU law infringement actions, in response to the judicial independence crisis in Poland. And actually, they have proved quite successful. And maybe if not stopped, they at least slowed down the process of overtaking, capturing key institutions of the judicial system. However, the European Commission has launched only one such proceeding related to an element of media freedom and pluralism. In the case of Hungary and Poland, it was in June 2021, and it is an infringement action related to the Media Council's decision in Hungary to deny Klub Radios an extension of its license. The European Commission has argued that this decision was disproportionate and breached the European Electronic Communications Code, and the case is still pending. So finally, just briefly, the question of financing. In recent years, the EU has committed itself to sustaining better media environment to ensure that quality media can survive and that it's possible to actually create new media. And it has included it in numerous financial instruments, notably in the EU budget, which is named the Multi-Annual Financial Framework. There are also other sources of funding for media, including the new fund named Citizens, Equality, Rights and Values Program that is aiming at promoting civil society initiatives that would uphold EU values. And this means that nonprofits, media nonprofits, can also potentially use this funding. Moreover, there is also the Media and Audiovisual Action Plan. And in this framework, the European Commission has launched an 8 million euros funding call for projects to support journalism partnerships in member states. And the European Commission has been not only giving out money to civil society and media organizations in grant-making procedures, but it also plans to boost the production distribution of audiovisual content in Europe by boosting investment, private investment in media in Europe. It also works with European philanthropic foundations to this end. So we see that this response is rather fragmented, and there are definitely certain elements that are good excuses for the European Commission to explain when asked about its actions that it actually has been doing a lot and trying to prepare ground for maybe possible legal actions in the future. Unfortunately, due to this fact that it appears that EU law is only narrowly focused on media issues, it gives a certain excuse to the Commission. But nonetheless, my recommendations for the EU institutions are the following. And I will say that these recommendations can be applied in a short term or medium term, and that they definitely should be applied before the European Parliament's elections. So first recommendation is that we need targeted EU political action that would protect media freedom and pluralism. So what is missing is that the EU is not applying enough pressure on member states' governments that violate media freedom and pluralism, and that the EU institutions should declare their support for media independence and denounce specific violations. So this is something that happened in the case of judicial independence, where after many years and after many years of work of the rule of law defenders, including Professor Morijn, and also grassroots civil society organizations, the European Commission has been quite responsive to the civil society alarms regarding specific violations, but we don't see comparable alertness and readiness of the Commission concerning media freedom and pluralism. Furthermore, it would be important that the Council of the European Union expands the scope of the Article 7 procedure against Poland to cover also the media freedom and pluralism issues. It is also essential that regular hearings in the Article 7 procedure are held against Poland and Hungary, and that during those hearings, the recommendations presented in the rule of law reports concerning media freedom and pluralism are also discussed and followed up. Furthermore, the EU institutions should consult with civil society to understand the dynamic model of media capture in Poland and Hungary, and they should swiftly condemn any attempts by the governments to silence civil society voices, including silencing those voices through gongos, so formally independent, but in fact government-linked organizations that exist in both countries and are a real threat to civil society and media there. And furthermore, I would say that it's really important that the EU works in coordination with the United States, in a friendly coordination, and that both EU and the United States push back against any legislation, any new legislation targeted against specific media organizations or sectors. Such new legislation can include new taxes that would disproportionately affect media criticizing the government, and that both United States and the EU should denounce specific threats to civil society. So the denunciation of such threats or violations by the European Commission President and Commissioners, or by the US President, Vice President, or ambassadors would have a profound impact in Poland and Hungary, because it would be greatly commented by media and it will reach public opinion. So another idea is that United States and its partners in the North Atlantic Treaty should also remind authorities in Poland and Hungary that NATO is also built on the respect of the rule of law, and that NATO also requires that public opinion is informed in a not biased, impartial way. And we can use here the example of Poland's Lex TVN, which was a law that was adopted by Parliament but vetoed by Polish president. And the veto happened after US envoy, as we think, informed or may have informed Polish authorities about the imminent Russian aggression in Ukraine. So we see that the United States have been a really important ally and stakeholder in upholding or countering media freedom and pluralism violations in Central Europe. And finally, and this is something that I would say was inspired by Professor Morijn and Professor Bodnar's op-ed in Politico last year, is the idea that the European Commission already has sufficient grounds to start targeted infringement proceedings related to media freedom and pluralism, because these actions can be definitely based on the provisions that protect electoral rights of EU citizens in European Parliament and municipal elections. So we have articles in the Treaty on the EU and Treaty on the Functioning of the EU that provide that citizens have the right to vote and stand as candidates in municipal elections in member states under the same conditions as nationals of that state, which means that EU law also applies to local elections, and we will have local elections in probably 2024 in Poland. So we see here that time is of the essence, and that EU already has, if it wants, it has provisions upon which it can build up cases. Moreover, there is also Article 230 of the Audiovisual Media Services Directive. That was already, this directive has been already transposed in both Poland and Hungary, so it's a law there. And this article requires member states to guarantee that their media market regulators are entirely independent of political and business influence and exercise their powers impartially and transparently. So this is another concrete element of the EU law that could be employed in a possible EU law infringement action. Finally, the European Commission can and should rely in these infringement actions directly on Article 2 of the Treaty on the European Union. This article enumerates EU core values that include freedom, democracy, equality, and the rule of law. So far, the European Commission has used Article 2 only as a subsidiary ground, but there have been many attempts, including from eminent experts of EU law, to convince the Commission to use Article 2 as the main ground for EU law infringement proceedings, and it could be done in both judicial independence cases and in media freedom and pluralism cases. And a last comment would be on the Media Freedom Act. So there is this danger that the planned Media Freedom Act would not address the fragmented regulatory framework, and actually that it would be used as an excuse for the Commission to not to take any legal steps before it's adopted. And we've seen only the draft, so there are also certain uncertainties regarding the proposed solutions, but the biggest threat would be that in this long legislative procedure, governments of Hungary and Poland and other states would basically blunt the teeth of this regulation. So it's crucial that the EU's deference to the approaches of member states in media regulation is not going to water down the draft MFA, and that the European Commission is not postponing or is not delaying its legal action, waiting until the MFA is finally adopted. And also, we need to be aware that even if the MFA is adopted, without restoring judicial independence in Hungary and Poland and independence of other checks and balances, application of this MFA in those countries would be severely limited. So this is also another element that I explore at length in my paper, that we should always think about safeguarding media freedom and pluralism in connection to safeguarding judicial independence, because the judicial independence is prerequisite for achieving all other goals, and no EU regulation would be enough without this element. So thank you very much.
Thank you very much, Anna, for this really exhaustive overview of both the challenges and the state of play until now. I would now pass the floor to John to react and comment on Anna's paper. And in the meantime, I would like to encourage all of you who are here with us to please feel free to share your questions, comments with us in the chat and the Q&A. I'm picking them up on the go. Thank you. John, the floor is yours.
Thanks. Many thanks for the invitation, and hello from The Hague. You see that behind me. When I was still in Brussels, I often benefited tremendously from working with the German Marshall Fund, so it's nice to be back. But it's a particular pleasure for me to comment on Dr. Wòjcik's paper. My main recommendation is actually a really lazy one. Read it yourself, not because I am actually lazy, but because it's impossible to do full justice to it here. I think her main point and my main takeaway is that she very convincingly demonstrates how this is indeed qualitatively different in terms of the approach by the European Union, and very fragmented in its approach. And also her second really important point is that you cannot really appreciate what's going on with media freedom without looking at a wider context, including, for example, with the links to judicial independence. So what I want to do is use this occasion simply to amplify a couple of the things and deepen a few of the points that Anna makes. So my overall point is really that we need to be aware, and I'm going to put this very sharply, that there is a media freedom and pluralism emergency in the European Union, particularly in Hungary and Poland, but not only there. And this threatens not only the internal market, not even mainly the internal market in my view, but other legally binding key EU values like democracy and human rights. And both these fields are EU competences too. So the good news is that there are different ways for EU institutions to, particularly the European Parliament and the Commission, to act like they really mean it, and I mean immediately, and particularly by protecting the integrity of the upcoming European Parliament elections in 2024. And that should be by law free and fair. I'm going to talk about that a little later. And by ensuring that all internal markets, citizenship and media related EU funding to member states is implemented in line with media freedom related rights in the Charter of Fundamental Rights. These are my key arguments. And in my comments, I want to focus first on what will likely not work. And Anja has just already explained quite extensively the European Media Freedom Act, which is what I'm referring to here. And then second, to end on a positive note, things that could immediately work, and I'm going to mention two there. So first, the thing that will likely not work, and this is what was proposed in September, the European Media Freedom Act. Why am I skeptical? You know, as a lawyer, I'm looking at first at the legal base and the legal form. And the legal base here is Article 114 of the Treaty on the Functioning of the European Union, which reads that the adoption of measures for the approximation of the provisions laid down by law, regulation, or administrative action in member states, which have as their objective the establishment and functioning of the internal market. So it's an internal market instrument. So this is all about taking away barriers and creating better conditions for more effective internal market for media companies. And Anna has already explained some of the purposes here, particularly, and also how they are controversial not only in the usual suspects, but also in countries like France and Germany. And so this also tells you that although it's quite a common practice for the Commission to sort of start really big in the hope that down the line something will be left, I'm quite skeptical here that something at all of relevance will be left at the end of the road. And that also has to do with the second element, and that's the choice of legal form. It's a regulation. A regulation means that national legislations will have to be replaced by pan-European legislation. So that means that we're going to have a lot more discussion here, a bit like with the general data protection regulation. And the context here is also bleak, given the starting point with regard to media freedom and media pluralism. If you look, for example, at the latest annual report on the rule of law by the Commission, more than a blocking minority in the Council has very serious problems with media freedom and media pluralism. So that means that it's going to be a really uphill battle to come up with something really of relevance in substance. And I think that Anna points out to a very important element of that. It now gives the perfect excuse for the European Commission, at least, to not do anything else. But if it's already clear from the off that this is going to really not lead that far, that's very dangerous. I also think that we need to learn our lesson from history, and also strategically, this was the wrong thing to do. And we should learn particularly from the experience with the rule of law conditionality regulation. The government most affected by this will be first watering down the proposal in the negotiations, then vote against it, and then use the vote against it to challenge all of this in court. It means that at least 4 or 5 years down the line, will be stuck with something that is far from ideal. So it's naive, in my view, to think that this legislative proposal in the current political context will lead to meaningful results. And it may be more about appearing to act than being focused on real results. And I think that what Anna is saying, that in the meantime, really sort of plugging this new element of the rule of law report in Article 7 discussions is sort of how it can be a little bit relevant, but I don't expect much from the legislation. So and then there, you know, I promised you, Susie, to end on a positive note, and that will be in 2 different ways. I think that there are things to be done in protecting free media as a matter of protecting elections that are covered by EU law, as Anna was already saying, and also as charter rights that relate to media freedom. I'm going to talk about these in turn. So let me start with elections. And here's a quiz question for all the EU law geeks that are out there. Which article in the EU treaties lays down a right to initiative, not for the Commission, but for the European Parliament? I'm going to answer my quiz question myself, and that is Article 223 of the Treaty on the Functioning of the European Union, which lays down the following: the European Parliament shall draw up a proposal to lay down the provisions necessary for the election of its members by direct universal suffrage. So in fact, the European Parliament is itself politically responsible for European Parliament elections. It has to then be approved by the Council, but this is the only right of initiative that the European Parliament has. So the European Parliament really has a stake in how at least the European Parliament elections are conducted. And there are also wider rules in EU primary law that relate to that. Article 10 of the Treaty on European Union says in so many words that we as EU citizens are directly represented at the level of the European Parliament. Article 20 of the Treaty on the Functioning of the European Union lays down our active and passive right to vote, and there's also various charter rights. But what I want to really focus on is something that is quite glaringly there already, and that could be very much used, and that is laid down in the Act concerning the election of members of the European Parliament by direct universal suffrage. And it reads in Article 1, paragraph 3, elections shall be by direct universal suffrage and shall be free and secret. They shall be free. That's the current ruling. That's the current rule. And that this has been in the law for over 30 years. And in a recent attempt to update these rules in 2018, there was unanimous agreement by all member states. That's very important, all member states. And it was also approved by a majority in European Parliament to add the following recital. And that's recital 4 of Council Decision 2018/994. And it reads, transparency of the electoral process and access to reliable information are important for raising European political awareness and for securing a solid election turnout. So there is clear legal standard, although this has not yet been approved, this adaptation that has to do with some wording on an election threshold that is no longer that wanted in Spain and Germany where it would matter. But the wording here is really that there's already a unanimous agreement, at the Council level, that transparency and media are important for elections. So why am I drawing your attention to this? The answer is, can there be free elections, which is a standard, without media freedom and pluralism? Can there be a transparent electoral process or access to reliable information without media freedom and pluralism? I think the answer is obvious, particularly around this friendly table. That's also why the OSCE monitors the media when it does election monitoring. So EU-level democracy and the European Parliament particularly, giving its own prime political responsibility, has a direct stake in national-level media pluralism. Its own future composition and legitimacy depends on it, because if come 2024, a number of people are elected into the European Parliament that are basically the product of what is effectively not a free and a fair election, that could also even affect the legality of its own composition. So this means, in my view, that the European Parliament should really prioritize pressuring the Commission to start an infringement based on this very wording. And while they're at it, as Anna was already saying, the Commission itself is also responsible for other elections that are covered by EU law, namely municipal elections, which of course have the same problem here. So media on freedom is a direct problem for democracy and elections covered by union law, and therefore this on freedom can be and needs to be directly confronted through union law. That's my first positive news. And the second, and I promise you a second one, Susie, too, and I'm coming to that now. And this to do with how you can link EU funds to EU basic values. I talk a lot to the media about the rule of law conditionality regulation and the current COVID funding, etc. And I often get the question, are these tools also relevant for what is now happening with regard to media, both in Hungary and Poland? And the answer is no. The answer is no, because the rule of law definition in the rule of law conditionality regulation does not contain media, nor does any of the country-specific recommendations that can be a milestone for issuing COVID funding. But there's another recent trend that is noteworthy in my view. It's sort of below the radar, but it's very promising for our purposes. And that is a trend that the Commission is now holding up cohesion funds to Poland based on Article 9.91 of an EU regulation with the unsexiest of names. It's called the Common Provisions Regulation. And this specific provision reads like a bit of a general rule, but it reads very specifically in this particular instrument. Member States and the Commission shall ensure respect for fundamental rights and compliance with the Charter in the implementation of the funds, and the funds are cohesion funds specifically. And given that Article 47 of the Charter that guarantees the right to access to an independent court is an issue in Poland now, the Commission has asked Poland to remedy these, and otherwise it will not release these funds. So my question really is at this stage, for the purpose of this discussion, does this also apply to other EU funds that directly link to media, market and citizenship? And does it also apply to charter rights that link to media? My reaction at this stage is a good question. We need to look into that better. There are some EU funding programs that deal with these areas, like, for example, the Creative Europe program that covers audiovisual industry and the so-called media strand. There's the Citizens, Equality and Rights and Values program that Anna already mentioned. And there's various internal market promotion programs. But the interesting thing is that they do not contain the same type of explicit wording like 9.1 of the Common Provisions Regulation. But on the other hand, you could argue, particularly if you ask a professor from the good lobby professors, that the Common Provisions Regulation was recently renewed and holds the most recent political consensus at EU level. That just like the rule of law regulations, that member states can simply not be allowed to spend EU money in a way that violates EU protected rights. So in my view, this is an area that should be looked at currently, and that is really a new front that could be used immediately. So I'm coming to a close, Susie. I want to address an elephant in this digital room that I'm often also asked. Are these sort of out there proposals from a disconnected professor? Are these actually realistic at all? I think they are. What I'm proposing is to look more deeply into what would be fully conventional, immediate applications of existing binding union law norms. With regard to media, what has been remarkable, regardless of all the nice democracy and human rights rhetoric, is the internal market-centered outlook and approach. Of course, media are businesses too and provide an economic service, just like I currently do by giving you this talk. And hopefully I get a proverbial bottle of wine at the end of it, or maybe you can make a donation on my behalf to a good NGO. But this, of course, is also an illustration why looking at the world purely as a business transaction is a very reductionist thing to do and misses a lot of what is really relevant about what we're doing here. So media are absolutely essential for democracy, free elections, and access to independent information by citizens, which are covered by EU law, and EU institutions have all the tools to enrich their enforcement of existing binding EU norms from that angle. So many thanks. I look forward to discussion, and let me remind you, read Dr. Wòjcik's paper. Thank you.
Thank you very much, John, and especially thank you very much for also bringing in some rays of hope and positive areas of action. So definitely the proverbial bottle of wine would be well deserved for that. Anna, would you have any immediate reactions before we move into our Q&A session?
Well, I would say that there's a need to combine two approaches of lawyers to big fields of law: constitutional law, fundamental rights law, plus EU competition law. And to me, it was, because I don't have experience in competition law, obviously it was quite difficult to integrate also this perspective. But I feel that we should do those two approaches, implement those two approaches at the same time, and demand the European Commission not to forget about this aspect of media freedom and pluralism as essential component prerequisite for free elections. And I was thinking about concrete cases that could be created, right? Because we are mostly like making certain like hypotheses, what could be actually the basis of a case. So I would say that there could be a case against media regulators based on this Article 230 of the Audiovisual Media Services Directive, because it has been transposed in both countries, as I mentioned, and that because we may see that media regulators are not politically independent because they never act against media that are controlled by the government, and they only act, for instance, in Poland, media regulators have fined TVN for actually covering street protests. So this fine was later revoked under the pressure from the United States, but we can make a strong case that media regulators are not independent. Plus, there is a strong, I would say, evidence that there exists some links between people who are in those regulators and the government, the president, etc. But I would say that we mostly should judge them and try to make this case based on their decisions. Including on decisions not to fine or not to launch probes into issues that citizens have raised in their complaints to media regulators. And as I mentioned, there are many complaints against, for instance, portrayal of opposition political party leaders, or there should be complaints made. Also, it's also another idea for civil society to make more complaints regarding the portrayal of European Parliament parties or groups. But I don't know, what, John, do you think about this? Is it realistic?
I think it is. I think that part of the fragmentation that you described is also the fragmentation in civil society, right? Because it's not so, because you need such a huge array of different expertises in democracy, in competition law, in all sorts of different ways to come up with a coherent strategy to come up with an actionable complaint. I think it's definitely something that could be very promising. Another thing that I would think could be very helpful, if I may, Susie. We often think about very complicated things if we think about the European Union in terms of having specific new funding streams or specific legislation, but some practical things can be very helpful. For example, who are the lawyers who support the wrong part of the case in the SLAPP case. Why don't we blacklist them? Why don't we ask the Commission to simply denounce in speeches that if there's a SLAPP case going on, that law firms that help the wrong case are basically killing their own protected brethren, because they're also a protected profession for a reason of the rule of law. Why would you then support the wrong side there? I mean, these are practical things, sort of blacklisting things or making this something that is becoming politically costly, and that could actually be useful in terms of having a market perspective, because it becomes less attractive for a commercial law firm to lend its services there. So not everything has to be so complicated. I think it's also a matter of just having focus there and seeing how you can really target the person that you want to target here. In this case, for example, law firms.
Thank you very much to both of you. In the meantime, we have received quite many questions. Before moving into that, I would like to abuse my position as the moderator for posing one question to you both. You were both particularly skeptical regarding the European Media Freedom Act under discussion at the moment. My question would be, how can we salvage this? What added value can really come out of this in the long term? While still, of course, we need to focus on also short-term measures. What would you see as an added value of it, if any, and how to ensure that we actually get there?
Anya, you can start.
Yes, okay. Yeah. Well, so I think that it's also like a good initiative that that we have at least now like a legislative process in which we as citizens, as members of NGOs, we can voice our concerns. We can also comment a proposal and refer to this proposal. So it's something concrete, and definitely we also have a proof that the Commission has already seen and acknowledged that these areas need to be protected better. So I think this is always an argument, and this is something that you know, it's always better to have like a benchmark, or at least to refer to an idea and say how it can be improved. So I think that the fact that this act is being discussed, it's already an achievement. So we are very critical because we want to see that things are moving faster and like with a broader scope. But it's already an achievement that due to years of flagging this issue by media, by civil society, by think tanks, we see that there is at least an idea. And this idea would never come up I think from the business sector, and we see it because the response of big media owners is, I would say, lukewarm to this idea, and they would be very I think they can use a lot of their own resources, including their legal teams, to try to diminish this legislation in parts that may threaten their economic interests, obviously, in producing media. But I would say that the part that especially that especially rings a bell in the case of Poland and Hungary is this need, it's the need to have not only independent regulators, but also independent management of public media. But this is a really big new competence that the EU is creating here, which means that the EU would have a bigger say over management of public media that exist in all countries, and that are often at least in some countries, are used as very potent campaign vehicles for the governing parties. So I suppose there would be a lot of opposition from the governments.
I agree with all of that. I just want to, I used to be a diplomat in Brussels, Susie, and the first question I always got when I worked there is, where is this discussed? And that tells you a lot about what are the political dynamics around it. So this has been attributed to the cult committee in the European Parliament. That means that the center of gravity is really about the internal market aspects around it. I think it would be very useful maybe to think about whether we can extend the legal base that I discussed earlier, 114, to include the ones that we were discussing, to have not a one, to have a more stable chair, so to say, to also include the democracy and the human rights elements to that, and make sure that LIBE and AFCO are more firmly involved in that. And that would also extend to the council for configuration. It would be very useful to discuss this in the General Affairs Council, in the Justice and Home Affairs Council, and not only in the people who only deal with media as a market. And because, as I said, I think that is very reductionist. The second thing, which is absolutely essential, and I think that Anna was already making this point implicitly, what is always problematic when the Commission proposes something that actually builds on a lot of existing binding standards, both within the European Union and the Council of Europe, is that you sort of risk renegotiating what is already legally binding. So it's really essential, given this playing field that was, I predicted this a year ago that was going to go nowhere, but then the Commission didn't listen, so maybe now they do. What they have to do is put out a two-pager as soon as possible with all the legally binding standards that are already there, so that at least we have a firm base what we can actually negotiate about, because otherwise we run the risk of having 5 years not only in delay, but we actually go down in standards, which have been agreed, for example, in Council of Europe setting. And that would be very useful also for us. And of course, this does not have to be done by the Commission, but can also be done by people like us to contribute to debate. But I would, still characterize all of this, Susie, as a salvage operation, like the way that you described it. More like a damage control kind of thing than that I really expect much in the current setting.
Thank you very much to both of you again. I would suggest that we move into our Q&A with the questions received from our audience. And it's quite many, so I've been trying to group a few of them together thematically. And since both of you were touching on the question of funding, especially John, but the question goes to both of you. I would start with this group. How available, one question goes, do you see current EU funding for independent non-profit media? How available, how accessible and utilized is this? By whom? And what can it really achieve? Another question touched on, like, how realistic would it be to really start investing into a Europe-wide media space? Is there an appetite for that you see? And if so, what can we expect in that regard? I would start with this and then throw some more questions at you in the next round.
Mm-hmm. So, I would say that there are several new funding instruments, including this Citizens Equality Fund that could be used by nonprofits. And I know that at least in Poland, certain organizations have been looking into that. And what I've seen in the EU's approach is that it tries to boost media, various types of media. So the media, the big conglomerates that would seek more investment, more, like for instance, venture capital investment in their media. But on the other hand, also the EU wants to encourage philanthropic foundations to create new media funds that would support nonprofits, and that created this citizens fund that I have already mentioned. So in terms of funding, well, I would say that at least judging from my experience in media nonprofits, it's I would say more training how to get this funding by nonprofits would be necessary, so they actually are not discouraged or afraid by the procedures and reporting requirements by the Commission. So I'm not saying that these procedures or requirements should be changed, but rather that we should train independent organizations how they can actually participate in those procedures, because I feel that at the moment this is a block, a big gate that keeps certain organizations from using it.
Yeah, I agree with that, Anna. I mean, I would like to make the more general point. I think that if you look at what is funded, part of the fragmentation that you mentioned earlier is also finds its translation in the fact that it is sort of underfunded in terms of a priority from the EU level. But I want to take this question in a more fundamental way, Susie, if you let me. I think that we have to really ask ourselves where or at what level are we actually protecting pluralism? And because it implied in your question that somehow we need to have a Europe-wide media space. I think that's totally unrealistic. I think that we have two different spheres. We have the Euro bubble sphere, the people that read Political Europe, that are very few people outside of Brussels, we have to realize. And we have 27 parallel national bubbles. And you know, European Parliament elections, for example, are 27 national elections that happen to be organized in parallel, but you know, purely legally they're national elections. So I think it's much better to focus specifically on the national bubbles first and make sure that there's a sort of a base there, and that requires a lot more money and just putting a lot more funding into journalism and independent journalism without any sort of strings attached and without any sort of requirements that it has to have a specific European Union angle or something, which is now still often the case for funding. And you know, part of the thing that Anna was mentioning, that if you're a small NGO, you often spend more time applying for funding than actually doing the work. And part of the thing that is really a hurdle is that it often feels very worked to find an angle with the European setting, because you're part of the one of the 27 national media bubbles, right? And that's fine, because that is also important for our democracy in Europe. So I think that this very fundamental question, where are we actually protecting something, is something that hasn't really been definitely answered. And it seems that this Media Freedom Act seems to hint is sort of premised on the fact that somehow this pan-European media space is better. I think that is not necessarily a premise that I agree with as such.
Thanks a lot. So in that case, let's move a little bit back to the national media spaces. And we have a lot of questions regarding that, but I would still stick with those that connected with potential EU action. We have some questions regarding developments that we actually do see or have seen in Poland and Hungary as well, which are fairly hard to really challenge, or have been apparently hard to challenge for now. Namely, there have been a case in Poland where the Polish government, by means of a state-owned company, purchased a big media conglomerate and therefore ensured a certain level of dominance in the media space. And we have seen such developments in Hungary as well, by the purchases of government-friendly businesses, of local papers and the like, not just print and traditional media, but also increasingly digital outlets. So when these transactions appear really like business transactions, but result in serious restriction of media pluralism, and freedom, what can the EU do? Is there ground to address it? Can we find such grounds? What tools are available, if any?
So in the PKN and Orlen takeover case, this case was controversial because it turned out that apparently the lawyers for Orlen, they've compiled the documents regarding the scope of Polska Press, this conglomerate, and it turned out that actually it's a bit bigger than the documents that according to the documents that they provided. And it turned out that this would mean that the transaction breaches competition rules under Polish and EU law. And therefore, Commissioner for Human Rights, Professor Adam Bodnar, filed a case, and that case was considered by a Polish court. And in the first instance, there was a court's decision that the transaction should not proceed. But as we've seen, the transaction was completed because the CEO of PKN Orlen publicly commented that this decision was invalid, and this was also commented in this way by Jarosław Kaczyński, PIS chairman. So what we can do about this? Definitely the enforcement of EU competition rules is an angle that we could try to apply in particular cases. So more discussion about it should apply. However, what is the root cause of the problem is that there is, in democracies, there should be no direct political influence on business decision to sell your assets. So we can, of course, try to make a campaign to try to convince those who own shares in media and private media in Poland or Hungary that they should reconsider their business transaction against human rights and democracy concerns. But I mean, being realistic, I don't feel that this would be like very effective. The other thing is that we may try to prevent legislative action against companies that exist and that are owned by private entities, both like national or international, foreign. And as it was with the case of Lex TVN, although this was probably possible due to very broad external geopolitical factors, but the law was not signed, so it didn't enter into force. And that was a huge relief for media community in Poland, and also a big signal to business that the Polish president, at least, but because not the government, not the parliament, would like to honor certain promises regarding protecting the transactions and the promises that it kept, and that basically the making business in Poland would be predictable. So I would see more potential in this angle, like trying to prevent government from introducing any legislation that is apparently targeted against a sector or a company.
I would answer the same question along the same lines from a different angle, Zsuzsi. Initially, I was criticizing the fact that an internal market focus is reductionist. But this is actually the one place where you could actually really use an internal market angle. And the reason why it doesn't really work is because somehow there's these silos within in the European Commission, and people within DG competition haven't really read the brief or my op-ed with Adam in Politico, that somehow there should be a more limited discretion with regard to member states, and I mean discretion for the Commission to act. If a member state is in Article 7 territory, you simply can no longer take cases at face value in the same way. You have to act much more decisively, in my view. So I think there's plenty of reasons to think that there's a problem with state aid, with distortion of competition, etc. If you simply completely put pressure and take over a whole business, because in this case it's really that, right? Both in Poland and in Hungary, or at least an attempt in Poland. So I think that I should nuance my earlier argument that internal market is good if it's really an internal market problem, and then you have to also be decisive in that regard. And I think that this would be definitely a case for that. But then on the other hand, as a footnote, I think that, as Anna said, you know, the real experts in this area, and I'm definitely not one, tell us that it's actually not always that clear cut. So it could be useful to, in terms of what is really being affected in the state aid rules, in the competition rules, etc. So if there's really gaps there, that could also be something that that should be, you know, plugged, simply because it should also make sense to the person within the four walls of DG competition, of course, to really, you know, at least go in it for the win.
Thanks so much. Since we drifted into the territory of competition law and various essentially business related issues when it comes to media, a bit away from questions of democratic quality and role of media pluralism in that, I would for a moment still stay here. We have a question regarding new business models in media. And the question particularly touches on the changes that we can see in digital economy today. And so I would pose it to you that way, that to what extent can we address questions of media pluralism, the challenges we observe, particularly in traditional media, but I think also in new media, in digital media, without really rethinking the approach towards digital media on an EU level regarding funding social media platforms and the like, and what role they play in media freedom and pluralism.
Well, I mean, it's essential that that this goes hands in hand. So now we are discussing this digital services directive, but there are also big hopes that responsibility of social media providers would finally be made into EU law at some point, and how social media platforms operate is vital for any digital-only media, and especially because social media in recent years have been really vehicles for smaller non-profits or like grassroots media startups to grow. And it's like a real experience of a medium that I worked for, that I wrote for. I could share that, you know, you start, you're based on one social network, and then after a couple of years, the algorithm changes. And if you do not focus and strategize to diversify your like website traffic sources from search engine, new social media, I mean, any other ideas that you can have, SEO optimization, then basically you are done. And today, when you are digital only medium, really you can write the best article in the world, but no one will see it if it's not up in on your feed or in your search engine results. So making maybe, so there were definite attempts by social media to try to give grants, for instance, so that non-profits can buy, so non-profits get grants to buy ads at this company. So non-profits have to support this business model, and they but at the same time, they produce good quality content that users of the social network can use. But this approach mostly works, of course, for the social media company that encourages or ties media to produce more content. And, you know, otherwise they wouldn't promote it, because who would have so many dollars to spend on your Google ads or Facebook ads? So I feel that, yes, that this definitely is also an element of the discussion that I personally haven't looked that much into, because it was a little bit too broad for this paper. But definitely this is like a real life problem and a question of survival for many media outlets.
Susie, I know my limits. I don't think I have anything intelligent to add to this.
Okay, thank you to both of you. Then we would switch topics again a little bit. We have a very particular question, more drifting back more to the area of legal questions. Considering that, at least in the case of Poland and Hungary, we do see that actually public broadcasters, due to their them being overtaken and by governing forces, do actually play a role in the shrinking of media freedom and pluralism, and really showing the plurality of views in their programming. What is the possibility for the European Union to act here to address these trends? And particularly the question concerned if this could be addressed under the Amsterdam Protocol.
Sorry, Susie, on the what protocol was that?
It was Amsterdam Protocol.
The Amsterdam Protocol, is that what you're saying? Okay.
Yeah.
Sorry, I don't. It doesn't really ring a bell for me. What's the Amsterdam Protocol in this context? Do you have any idea, Anna?
I was just Googling. Maybe it's just the treaty revision, Amsterdam Treaty revision, which would mean that if we can use the treaties to answer to dissent, right?
Okay.
Well, I was thinking about it. I mean, a lot during my research for this paper, and yes, and basically what sort of decisions, what sort of decision of national authorities could be challenged, because I was thinking that besides the OSCE audio reports on the content of actually public media reporting on electoral campaigns, we don't really have that many studies. I mean, hard evidence. So of course there are analyses produced by even by individuals, former journalists in Poland who are watching news programs and are making statistics about how many times they mention in what context the name of the opposition leader, whatever. But I think it's for lawyers, it could be quite difficult to make this case, right? You would need to screen all the, and to be fair and to answer to this what about situation in France or Spain, you would need to do a comprehensive monitoring on news programming in all public media in all member states, probably, to then have some findings and then perhaps maybe use it as maybe not a basis for legal action, but at least for political discussion within the Article 7 procedure or in the rule of law reports. And this is something that actually maybe could be done. But on the other hand, I feel like I personally always have two big hopes regarding the scale of Brussels bureaucracy. And at the end, it turns out that there are only 5 people who are dealing with the rule of law reports for all those countries. So, we should hire another 5 maybe to do this job. But it turns out that this Brussels bureaucracy is just not enough to cover all and to answer to all our great ideas, right? So I don't have an answer, I only have some questions.
Yeah, I'm going to answer this question from a different angle, Susie. I think part of the reason why we are having this discussion is because we're always looking for sort of a thing that could work, a standard that could work in all EU member states at the same time, right? I think that part of the benefit of the approach that Adam Bodmer and I suggested is that rather than top down, you start bottom up. You ask the court of justice, in this case, what does it actually mean as a minimum in terms of public media to have free elections, specifically with regard to public media? Maybe then they start with conditions on which you can actually build that standard rather than immediately thinking about that standard, specifically if you do that from the very specific angle of only internal market and not having a more comprehensive viewpoint. And the reason is that such a judgment and the added value of such a judgment, Zsuzsi, would then be that perhaps what works in terms of having a good spread of different type of media also depends really on the size of your country, right? If you're Cyprus or Malta, perhaps the standard that we're now sort of putting in a European setting, it does not really apply that well to Denmark or the Netherlands. So perhaps the condition for what is required in terms of media freedom from a different angle, free and fair elections, could also be, we could basically, let me answer it differently. We could start perhaps more from the conditions rather than from the what is required for free and fair elections, rather than having the media standard itself in mind.
Yes, and John, this could be done by judges, right? I mean, so ideally, like a judge in a member state asks this question based on a case that is considered, but then there should be a case regarding participation in the elections to the European Parliament or municipal elections. So there's this link with EU law, right?
Yes, exactly. I mean, imagine, for example, that somebody in Krakow is on the list for the municipal elections from the opposition party, and he makes the case, listen, I got the 5 minutes that Marquis got in my specific context. This is a violation from my passive right to vote for municipal elections because it's an EU obligation. He goes to a Polish judge that can then ask a preliminary question: what does it actually mean to have a free election covered by EU law? And then that question could be answered by the European Court of Justice and lay down conditions. So you start more from the bottom up, from a different angle, rather than immediately coming up with some sort of proposal for a pan-European legislation from a very specific angle of internal market only. It's a different approach, but I think it's perhaps less top-heavy. And you could have a similar sort of case. Imagine, for example, that in Hungary, the situation unfortunately doesn't change, and somebody who was trying to stand for a membership of the European Parliament is not elected because he simply hasn't been able to convince sufficient number of people to vote for him or her, and he or her makes the case that is very similar. Perhaps you can also sort of, in the way that the European Parliament certifies each of the national results for the European Parliament elections, there's also an assessment there. And at that assessment level, perhaps you can simply challenge that assessment and go as a potential member of European Parliament to the European Court of Justice and make that more of an individual case and make the same kind of judgment. They just have to call the good lobby professors in time to make such a case. But there's many different angles, just all the traditional routes for that EU law provides. But now we have the route that the European Commission has set for 2 years and trying to think of some sort of European meta standard that is sort of a top-down thing. And it's really a sort of a strategic question whether that was the most fortunate way to start a discussion about this very important topic.
Thank you very much for that. I'm afraid that although we have not reached the end of the questions we have received, we have very much reached the end of the time we had available for this discussion today. I think we have touched on really a wide array of topics, and Anya's paper definitely provides a lot of food for thought and recommendations on really actionable items for the near future as well. I would like to give the chance to our speakers for any concluding thoughts, very brief takeaways that you would still like to maybe repeat or amplify, so our audience can take that away with them. Maybe, John, let's start with you, and we will close with Anya.
Great. So I have two recommendations. The first one I've already made twice in my talk. Read Anya's paper, because it's a very good paper. You should definitely take note of that and read it carefully. I think that this thing that that we discussed about salvaging the European Media Freedom Act, because I don't think that based on the German Marshall Fund webinar, this thing will disappear overnight, right? So we're in the how to do damage control kind of mode. I think if any of the think tankers around the table here is really able to provide a two-pager, what is already binding and what should be the basis of this discussion, so that we don't reopen discussions about things that are already binding in terms of 230, Article 230 of the Audiovisual Media Act, or the regulation or directive that Anna mentioned, but also all these Council of Europe standards. I think it would be very helpful contribution, because it would at least give some direction to the discussion. So I think that I want to stop on a positive note. I think there are many binding standards. There are independent judges sitting in the European Court of Justice. You just have to reach them, and we have to strategize how to get there, and not wait for the train wreck that is likely to unfold in front of our eyes in the next 6 years, called the European Media Freedom Act.
Thank you, John.
Yes, so I would basically maybe want to conclude with the fact that we should reinforce the EU institutions. So we should maybe try to praise them for the efforts that they've been already done, but also to emphasize that there are certain avenues, especially those legal avenues that John mentioned extensively, but also political avenues, including the scope of Article 7 procedure that, for instance, could be expanded regarding Poland, and that hearings should be held more regularly, and that now we have those recommendations in the rule of law reports, no specific forum where they can be discussed in addition to national parliaments. So hearings in this procedure are really a good and promising avenue and venue to do so. And I'm really looking forward to hearing your comments on my paper. I know that there must be some gaps, and it was like an exercise in trying to also, actually digest and synthesize, because we have been discussing that, yes, there are no EU law standards regarding media freedom and pluralism, and they are very limited. But on the other hand, there is so much of the Council of Europe standards that are very specific, and that these standards, they could be the basis of actually any EU level legislation, because the problem is that these standards are not enforceable. So actually the Commission should not look anywhere but there to something that has been already achieved, well thought, and produced since, like, I don't know, a couple of decades. And there are also many good practices included in the annual rule of law report of things that exist in certain member states. And I think that the Commission has not yet used enough this potential of learning or peer pressure, or trying to make arguments based on not always bad practices, but also some good practices that exist in other member states. And thank you very much for attending this this webinar, and for you, Zuzi, and you, John, for taking time this afternoon.
Thank you very much, and indeed, thank you both to Anya and John for this excellent discussion. It's been very insightful and very inspiring, and the topic itself is going to remain with us at GMF as well. Not only we are continuously working on the issues of democracy in Central and Eastern Europe, but we are also specifically following developments around the European Media Freedom Act as well. So this will remain on our table, and Anya's paper has definitely contributed to this channel as well. To those of you who have joined us this afternoon or morning, thank you very much for your time and attention over the past 1.5 hours. Please stay tuned. We have several other ReThink.CEE launches in the pipeline coming up with really excellent topics. Our next presentation is going to be towards the end of the month, focusing on inequalities in Central and Eastern Europe, particularly the situation of minority groups and Roma women and girls. So stay tuned. If you are on our mailing list, you will definitely hear about this, but you can also follow us on Twitter, and then you will learn what's new. Once again, thank you very much for joining, and indeed read Anya's paper. It's an excellent overview and some really thoughtful recommendation towards the way ahead. So thank you for being here. Thank you to both of you. Bye-bye.
Bye.